Imagine this. You are a government employee. You have just crossed 50 or 55 years of age. There is no departmental inquiry pending against you. No charge sheet has been issued. No court has convicted you. One morning, an order arrives on your table. The government has decided to compulsorily retire you in public interest under FR 56J. Your immediate reaction would probably be, how is this possible? If I have done something wrong, prove it. Conduct an inquiry. Give me a chance to defend myself. And at first glance, that reaction sounds perfectly reasonable. But this is where service law becomes very interesting. There exists a provision in government service rules called Fundamental Rule 56J, which gives the government the power to compulsorily retire certain employees before their normal retirement age if their continuation in service is considered not to be in public interest. Notice something important. The rule does not say the employee must be guilty of misconduct. The rule does not say a departmental inquiry must first establish charges. And the rule does not say the employee must have committed a punishable offense. This is why FR 56J has generated litigation, controversy, fear, and misunderstanding for decades. Today, let us understand what this rule truly is, why it exists, what safeguards courts have created, and what every government employee should know about it. Because once you understand the philosophy behind FR 56J, many things that initially appear unfair begin to make legal sense. Let us start with the most important point. FR 56J is not a punishment. This statement surprises many people. After all, if somebody is forced to leave service before reaching the normal age of superannuation, how can that not be a punishment? The answer lies in the distinction between punitive action and administrative action. Suppose an employee accepts a bribe. The government wants to punish him. In such a situation, a disciplinary proceeding is initiated, evidence is collected, witnesses are examined, the employee gets an opportunity to defend himself, and if the charges are proved, a penalty is imposed. Now, consider another situation. An employee may not have committed any single serious act enough to justify disciplinary action. However, over many years, his performance has steadily declined. Files remain pending, efficiency is poor, complaints repeatedly arise, questions regarding integrity continue to surface. His overall contribution to department has become doubtful. The government may feel that retaining such an employee until the age of 60 serves no public purpose. This is where FR 56J enters the picture. The purpose is not to punish past misconduct. The purpose is to assess whether continued retention of the employee is beneficial for public administration. Think of it as a quality control mechanism. Every large organization periodically evaluates whether people occupying important positions continue to justify their presence or not. The government is no different. But if this power exists, what prevents misuse? Excellent question. And that brings us to one of the most important Supreme Court judgments on this subject, the case of Colonel J. N. Sinha. The Supreme Court's judgment in Colonel J. N. Sinha remains the bedrock of compulsory retirement law because it clearly defined both the power of the state and the protection of the employee. First, the court upheld the constitutional validity of FR 56J itself, confirming that the administration holds an absolute right to retire a government servant after they cross the age threshold. Some had argued that the age distinction, treating those at 50 differently from those at 55, was discriminatory. But the Supreme Court rejected this, ruling that under Article 14, this classification is perfectly reasonable because it is directly tied to maintaining the efficiency of public service. This brings us to the part of the judgment that causes the most anxiety, the exclusion of natural justice. The court explicitly held that because FR 56J by its very nature excludes a prior hearing, an officer cannot demand one. Now, why would the highest court allow this? Because of a vital distinction regarding Article 311(2). The court observed that compulsory retirement under this rule casts no stigma. It does not amount to dismissal or removal. You do not lose your accrued rights, and your pension remains completely safe. It is an administrative exit, not a punitive one. However, this absolute right does not mean the government has a blank check. The court laid down a strict boundary for judicial review. While courts cannot act as appellate authorities to double check if the government's decision was correct, they will step in if the decision lacks bona fide intent, if the opinion was formed on completely irrelevant grounds, or it is transparently arbitrary. The protection of the law remains available to the employee. This judgment remains the primary precedent for compulsory retirement cases under Indian government service law. Link to the original judgment is provided in the description. Let me give you a practical example to illustrate this subtle yet extremely important distinction. Imagine a police department reviewing officers who have crossed the prescribed service threshold. One officer has repeatedly received poor performance assessments for the last 10 years. Several complaints regarding integrity have been received. None of them individually resulted in a successful disciplinary proceeding. Yet, collectively, they create a serious doubt about his suitability. The review committee may conclude that the public interest would be better served if such an officer is compulsorily retired. That decision may be legally sustainable even without proving a specific charge. Now, let us look at the second landmark judgment that forms the absolute foundation of this rule, the Supreme Court's decision in Baikuntanath Das versus Chief District Medical Officer. This case arose under the Odisha Service Code, where an officer challenged his compulsory retirement on two very specific grounds. He claimed that decision was driven by malice and that the department had unfairly relied on secret, uncommunicated adverse remarks in the file. Both the High Court and the Supreme Court ultimately dismissed the officer's appeals and upheld the retirement, establishing a set of binding legal principles that govern FR 56J to this day. The core of the Baikuntanath Das ruling solidifies the exact legal nature of the government's power. The Supreme Court clarified that compulsory retirement is fundamentally an executive function, which means the government's subjective satisfaction is paramount. And because it is a purely administrative exercise of executive discretion rather than a quasi-judicial trial, the court firmly re-emphasized that the principle of natural justice have absolutely no place in this context. But the truly groundbreaking observation in this case, and the reason it remains highly litigated today, revolves around confidential career entries. The Supreme Court ruled that uncommunicated adverse remarks can legally be considered for compulsory retirement. This means that even if a negative entry or low grading in your annual performance report was never officially communicated to you, the review committee is fully within its rights to weigh it. They are evaluating the entirety of your career, not just the parts you were notified about. Much like the Sinha precedent, the court concluded that while the executive has wide latitude, the door to judicial review is not entirely closed. However, the grounds for a court to step in are incredibly narrow. An officer must conclusively prove either malafide intent, a total absence of evidence, or gross arbitrariness. Short of that, the subjective satisfaction of the state stands. Link to the original judgment is provided in the description. This principles-driven approach brings us to how a review committee actually evaluates an officer's file. The law is unequivocal. The entire service record must be taken into account. The committee cannot selectively look at only recent years, nor can they base their decision solely on mistakes made decades ago. With that said, courts recognize a practical reality. Greater weight is naturally afforded to recent performance because it reflects your present utility to the organization. If an employee struggled 20 years ago but has delivered exemplary service for the last decade, it is unjust to judge them based on distant history. Conversely, past glory cannot shield an employee whose efficiency has completely collapsed in recent years. This clarifies a massive misconception that routinely circulates in employee groups. The idea that a promotion automatically wipes out all previous adverse entries. Legally, this is a myth. While a subsequent promotion certainly reduces the gravity of older negative remarks, proving the employer found you fit for higher responsibilities at that time, the Supreme Court has clarified that a promotion is not an automatic eraser of history. The review committee still retains the full legal right to examine the complete picture of your career. Where this review becomes absolute is on the question of integrity. In public service, integrity is not just a preference, it is a non negotiable threshold. Consider the administrative calculus here. If an employee is average in efficiency but fiercely honest, they pose a manageable challenge. But if an employee is highly efficient yet carries a persistent, documented cloud over their integrity, they pose an unacceptable risk to public administration. This is why material reflecting on an officer's integrity carries immense weight during an FR 56J review. So, when an order is passed, what is the true scope of judicial review? Can an employee challenge it? Yes, but the legal scope is incredibly narrow. Many employees approach the courts simply arguing that they disagree with the government's assessment. That argument fails almost every time. The writ court will never substitute its own opinion for that of the executive. Instead, the court strictly limits its scrutiny to three fundamental questions. Was the decision activated by malified intent? Was relevant material ignored? Or was completely irrelevant material weaponized? And finally, was the decision so perverse and arbitrary that no reasonable authority could have ever arrived at it? If the answer to these questions is no, the court will step back. They are reviewing the lawfulness of the decision-making process, not the merit of the decision itself. It is no different than a school principal evaluating a teacher. A court will not micromanage the principal's academic judgment. It will only ensure the evaluation followed the established rules of the institution. The ultimate lesson of FR 56J is a critical wake-up call for every government servant. Security of tenure in public service is not a license for stagnation. Surviving an entire career isn't merely about avoiding major disciplinary penalties or charge sheets. It is about maintaining a consistent standard of efficiency, professionalism, and integrity from day one. Every annual performance appraisal, every official remark, and every recorded assessment builds a long-term profile. When the threshold arrives and that review committee sits behind closed doors, that profile speaks for you. FR 56J is neither an unchecked weapon of tyranny nor a tool of arbitrary ouster. It is a balancing mechanism. It weighs an individual's right to employment against society's absolute right to an honest, efficient, and dynamic public administration. The next time you hear that an officer was retired without an inquiry, look deeper. Understand that it wasn't a punishment for a proven crime. It was an administrative assessment of public interest, and masterfully navigating that distinction is the key to understanding the true framework of service law in India. That, my friends, is the real story behind FR 56J.